Good morning, everyone. I call to order this 21st meeting for calendar year 2012 for the Public Utility Commission. I ask that you all join us this morning in the Pledge of Allegiance. Pledge of allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. The first item on the agenda this morning is the approval of the minutes from the October 24th meeting. I believe, Commissioner Cawley, you are the editor of the minutes.
Yes, Chairman, I am, and I have reviewed the minutes of our public meeting of October 24th, and I move that we adopt them as submitted.
Second. Any discussion? Any objections? Hearing none, the minutes are approved as submitted. And before I recognize Cheryl Walker Davis, I want to recognize Commissioner Cawley. I understand we had a little problem with our phone system this morning. There was someone that had hacked the system, and they were playing fight songs of each school. And I understand the Notre Dame fight song made it on a couple voicemails this morning, as well as the United States Naval Academy fight song. So, but it's to commend you, your alma mater, on being number one in college football.
And I hope that holds true after a certain game coming up.
Well, with that in mind, we'll have a little levity here before we get into the serious business. I'd like to recognize Cheryl Walker Davis to begin this morning's public meeting. Cheryl?
Thank you, Mr. Chairman. Good morning. Good morning, Commissioners.
Good morning.
May it please this Honorable Commission, on behalf of your various offices and bureaus, we present for your consideration and disposition the following agenda items. We will commence this morning with matters of special interest, cases of special interest on page 1 of the public meeting agenda. And the first item there appearing is the general rate increase request of the PPL Electric Utilities. The Commission will be acting this morning on a binding poll, the binding poll having the same effect as a vote. I would note that there are 28 issues. The issue sheets which have been prepared are used only as a guide to facilitate the orderly disposition of the issues in the case. They are not intended to be fully reflective of all of the positions of the parties. The Commissioners have based their decisions on the full evidentiary record in this proceeding. It should be noted that with regard to this poll, there will be 2 motions. There is your motion, Mr. Chairman, as well as the motion of Commissioner Cawley. There are also 2 statements, the statement of Commissioner Gardner and the statement of Commissioner Cawley. I would note that the motions and statements in some instances do apply to multiple issues which will be identified as we proceed. With that having been said, the first issue on page 1 pertains to the rate-based depreciation calculation, and more specifically, the depreciation reserve.
Commissioner Whitmer.
ALJ.
Commissioner Cawley.
ALJ.
Commissioner Gardner.
ALJ.
Vice Chairman Coleman.
ALJ.
I, too, support the ALJ position. Results of this polling case are 5-0.
Issue number 2, rate-based cash working capital, the expense lag days for payments to affiliates.
Commissioner Whitmer.
ALJ.
Commissioner Cawley.
ALJ.
Commissioner Gardner.
ALJ.
Vice Chairman Coleman.
ALJ.
I, too, support the ALJ position. Polling results are 5-0.
Issue number 3, rate-based cash working capital, the cash working capital claim, and the prepayment of postage expense.
Commissioner Whitmer.
ALJ.
Commissioner Cawley.
ALJ.
Commissioner Gardner.
ALJ.
Vice Chairman Coleman.
ALJ.
I, too, support the ALJ position. Polling results are 5-0.
Issue number 4, rate-based cash working capital, specifically the prepayment of regulatory assessments.
Commissioner Whitmer.
ALJ.
Commissioner Cawley.
ALJ.
Commissioner Gardner.
ALJ.
Vice Chairman Coleman.
ALJ.
I, too, support the ALJ position. Polling results on this matter are 5-0.
Issue number 5, turning now to expenses and incentive compensation.
Commissioner Whitmer.
ALJ.
Commissioner Cawley.
OCA and I&E.
Commissioner Gardner.
I&E.
Vice Chairman Coleman.
ALJ.
I, too, support the ALJ position. Polling results on this case are 3-2 in support of, the ALJ position.
Issue number 6, with regard to PPL services and environmental management expense.
Commissioner Whitmer.
PPL.
Commissioner Cawley.
ALJ.
Commissioner Gardner.
ALJ.
Vice Chairman Coleman.
ALJ.
I support the PPL position. Polling results in this matter are 3-2 in support of the ALJ position.
Issue number 7, with regard to PPL services and external affairs expense.
Commissioner Whitmer,
PPL.
Commissioner Cawley,
ALJ.
Commissioner Gardner,
ALJ.
Vice Chairman Coleman.
PPL.
I, too, support the PPL position. Polling results in this matter are 3-2 in support of PPL.
Issue number 8, with regard to the storm damage expenses and the storm damage insurance expenses reserve account.
Commissioner Whitmer,
PPL.
Commissioner Cawley,
PPL.
Commissioner Gardner,
PPL.
Vice Chairman Coleman.
PPL.
I, too, support the PPL position. Polling results are 5-0 in support of PPL.
Turning now to payroll, employee complement, and PPL's future test year employee complement.
Commissioner Whitmer,
ALJ.
Commissioner Cawley,
OCA.
Commissioner Gardner,
OCA.
Vice Chairman Coleman.
ALJ.
I, too, support the ALJ position. Polling results are 3-2 in support of the ALJ position.
With regard to uncollectible accounts expense and the appropriate percentage for those expenses, noting the statement of Commissioner Cawley, which applies to multiple items.
Commissioner Whitmer,
PPL.
Commissioner Cawley,
ALJ, and rather than read my partial dissent on a number of these items, I will just enter the statement in the record as if I had read each of these items individually. My position here is the ALJ's position.
so noted. Commissioner Gardner,
ALJ.
Vice Chairman Coleman.
PPL.
I, too, support the PPL position. Polling results are 3-2 in support of PPL, noting the partial dissent of Commissioner Cawley.
Issue number 11, rate case expense revised, and the normalization period.
Commissioner Whitmer,
PPL.
Commissioner Cawley,
ALJ.
Commissioner Gardner,
ALJ.
Vice Chairman Coleman.
PPL.
I, too, support the PPL position. Polling results are 3-2 in support of PPL.
Issue number 12, low income usage reduction program funding level, and CEO's proposal to increase funding for universal service programs.
Commissioner Whitmer,
ALJ.
Commissioner Cawley,
ALJ.
Commissioner Gardner,
ALJ.
Vice Chairman Coleman.
ALJ.
I, too, support the ALJ position. Polling results are 5-0.
Issue number 13, with regard to consumer education program expenses.
Commissioner Whitmer,
ALJ.
Commissioner Cawley,
ALJ.
Commissioner Gardner,
ALJ.
Vice Chairman Coleman.
ALJ.
I, too, support the ALJ position. Polling results are 5-0.
Issue number 14, with regard to the rate of return capital structure, hypothetical versus actual.
Commissioner Whitmer,
ALJ.
Commissioner Cawley,
ALJ.
Commissioner Gardner,
ALJ.
Vice Chairman Coleman.
ALJ.
I, too, support the ALJ position. Polling results are 5-0.
With regard to issue number 15, that being the rate of return, the cost rate of common equity, and the ALJ's sole reliance on the discounted cash flow analysis, we have your motion, Mr. Chairman, which applies to issues number 15, 16, and 17. We also have the statement of Commissioner Cawley.
Thank you. Before us for disposition is the recommended decision of Administrative Law Judge Susan Caldwell in the above referenced PPL Utilities Corporation-based rate case, which was filed on March 30th of calendar year 2012. Exceptions and reply exceptions were filed. Rate of return on common equity is frequently the most material and most contested item in a basic rate case proceeding. This is no different, and the setting of ROE is even more critical as our Pennsylvania utilities seek to implement plans to accelerate a much-needed replacement of their aging infrastructure. Attracting capital to Pennsylvania at reasonable rates has never been more important to PPL and many of our other utilities here in Pennsylvania and its customers and the Commonwealth. In this case, the range of the ROE recommendation presented by the parties based on the discounted cash flow, the DCF methodology, is 8.38% to 11.25%. This morning, I would recommend that we adjust this initial range to 9% to 11.25%, which excludes a proposed adjustment to the DCF growth rate based on a linear regression analysis. Based upon our review of the testimony, data, and cost models presented, as well as briefs and exceptions that were submitted, we believe that the record of evidence in this case supports an ROE finding in the reasonable range of 9.75% to 10.5% using the DCF method as the foundation. Considering PPL's need to fund $1.6 billion in distribution system improvements from calendar year 2012 to 2016, along with the results of ROE models other than DCF, I note in parentheses a necessary check that negates the need for a leverage adjustment and management effectiveness, the ROE should be set here at 10.4%. Therefore, I move this morning that the Office of Special Assistance prepare an order consistent with this motion.
Second.
Any further discussion?
Chairman, I would adopt the ALJ's position instead, so I respectfully will vote in the negative.
So noted. Any further discussion? We note the objection of Commissioner Cawley. The motion passes 4-1.
We would note for clarity of the record of the transcript that Commissioner Cawley's statement does apply to issues 15, 16, and 17 as well as the other issues that will be identified. With the motion having dispensed of issues 15, 16, and 17, we will now move to issue number 18 with regard to taxes, appearing on page 18, and that pertains specifically to the gross receipts tax.
Excuse me 1 second. I'd like to recognize Commissioner Gardner.
Mr. Chairman, in regards to item 17, rate of return, on your motion, I will concur on results only.
So noted. We'll move on to now page 18 of the agenda. This item involves gross receipts tax. We'll recognize Commissioner Whitmer.
ALJ.
Commissioner Cawley.
ALJ.
Commissioner Gardner.
ALJ.
Vice Chairman Coleman.
ALJ.
I too support the ALJ position. Polling results are 5-0.
With regard to issue number 19 pertaining to the rate structure cost of service and the cost of service study, it should be noted that there is the statement of Commissioner Gardner, which applies to issues 19, 20, and 21, as well as the previously identified statement of Commissioner Cawley.
I'd like to recognize Commissioner Whitmer.
ALJ.
Commissioner Cawley.
OCA.
Commissioner Cawley, we're also going to recognize your statement for the record. Been read earlier.
Correct, thank you. It applies through 19 through 20.
Correct. Commissioner Gardner?
OCA, and do I do my statement?
Yes, you do. We'd like to recognize you for purposes of your statement.
Thank you. I'd like for my statement to be entered into the record as if I read it in its entirety. This dissenting statement applies to the polling sheet issues 19, 20, and 21, rate structure, cost of service study, revenue allocation, and scale back from proposed revenue to allowed revenue. I dissented on the cost of service study used by PPL in its 2010 base rate case, and I do the same here. In 2010, the system average rate of return was 6.33%. Using the cost of service methodology submitted by PPL in its 2004 and 2007 distribution base rate cases, the primary residential class received 83% of the system average rate of return. This is an important point to make because the Commonwealth Court decision in Lloyd made clear that PPL should move its classes to the system average rate of return with deliberate haste. PPL then committed to achieving a rate design reflective of the cost of serving the classes within the three rate classes. In the 2010 case, the third case of those cases, PPL proposed using a new cost of service methodology, which resulted in the residential classes providing a return equal to 49% of the system average return. In accepting the new cost of service methodology in the 2010 case, the Commission essentially moved the goal line further down the field just as the residential class was close to reaching it. In the present case, PPL utilizes the 2010 cost of service methodology, which brings the primary residential class to 74% of the system average at present rate. If the pre-2010 methodology was used, the residential class would be at 112% of the system average rate of return. The result of the change to the cost of service method that was made in 2010 and followed in this case is that the residential class will continue to bear the majority of any rate increase unfairly. For this reason, I respectfully dissent from the majority on the adoption of PPL cost of service study. Instead, I support the OCA's cost of service study, which is consistent with the 2010 methodology, with the pre-2010 methodology. Thank you.
Thank you, Commissioner Gardner. Now I'd like to recognize Vice Chairman Coleman.
ALJ.
I too support the ALJ position. Polling results on this matter are 3-2, noting the statements of Commissioner Cawley and Commissioner Gardner.
Turning now to issue number 20, pertaining to rate structure, cost of service, and the revenue allocation. It should be noted that Commissioner Cawley's statement applies to this. We also have Commissioner Gardner's statement as well.
Commissioner Whitmer.
ALJ.
Commissioner Cawley.
Which item are we voting on?
We're on page 20,
Number
and this
20.
is the revenue allocation.
Okay, this again, OCA.
And we'll recognize again for the record your
I dissent.
statement.
Yeah.
And now I'd like to recognize Commissioner Gardner.
OCA,
And Commissioner Gardner, on my notes here, you have a statement?
it's the same.
Same statement. We'll note that for the record. Vice Chairman Coleman.
ALJ.
I too support the ALJ position. Polling results in this matter are 3-2 in support of the ALJ position.
With regard to issue number 21, continuing with the rate structure and the cost of service, the scale back from proposed revenue to allowed revenue, and it should be noted that Commissioner Gardner's statement applies to this as well.
Commissioner Whitmer.
ALJ.
Commissioner Cawley.
ALJ.
Commissioner Gardner.
OCA,
And again, we'll note for the record your statement. Vice Chairman Coleman.
ALJ.
I too support the ALJ position. Polling results in this matter are 4-1 in support of ALJ, noting the statement of Commissioner Gardner.
With regard to issue number 22, rate structure, tariff structure, and the rate design residential customer charge, it should be noted that Commissioner Cawley's statement applies to this as well.
So noted. I'd like to recognize Commissioner Whitmer.
ALJ.
Commissioner Cawley.
I&E.
Again, for the record, your statement is recognized in this matter. Commissioner Gardner.
INE,
Vice Chairman Coleman.
ALJ.
I too support the ALJ position. Polling results in this matter are 3-2 in support of the ALJ position, noting again the statement of Commissioner Cawley.
Issue number 23, rate structure, tariff structure, the rate design non-residential customer charge.
Commissioner Whitmer.
PPL.
Commissioner Cawley.
I&E.
Commissioner Gardner.
INE,
Vice Chairman Coleman.
PPL.
I too support the PPL position. Polling results in this matter are 3-2 in support of the PPL.
Issue number 24, continuing with rate structure and the tariff structure. This applies to the proposed competitive enhancement rider.
Commissioner Whitmer.
ALJ.
Commissioner Cawley.
ALJ.
Commissioner Gardner.
ALJ,
Vice Chairman Coleman.
ALJ.
I too support the ALJ position. Polling results in this matter are 5-0 in support of the ALJ.
Issue number 25, rate structure, tariff structure. This pertains to the purchase of receivables and the recovery of the uncollectible accounts versus the non-bypassable distribution charge.
Commissioner Whitmer.
PPL.
I'm sorry, that's the non-bypassable distribution charge.
Knew what you meant. PPL.
PPL. Commissioner Cawley.
PPL.
Commissioner Gardner.
PPL,
Vice Chairman Coleman.
PPL.
I too support the PPL position. Polling results are 5-0 in support of PPL.
Issue number 26, with regard to the rate structure, tariff structure, and the purchases of receivable, the uncollectible accounts expense factor.
Commissioner Whitmer.
ALJ.
Commissioner Cawley.
OSBA.
Commissioner Gardner.
OSBA,
Vice Chairman Coleman.
ALJ.
I too support the ALJ position. Polling results in this matter are 3-2 in support of the ALJ.
Issue number 27, continuing with the rate structure, tariff structure, purchases of receivable. This issue pertains to the late payment fee offset to the uncollectible accounts expense.
Commissioner Whitmer.
ALJ.
Commissioner Cawley.
ALJ.
Commissioner Gardner.
ALJ,
Vice Chairman Coleman.
ALJ.
I too support the ALJ position. Polling results are 5-0 in support of ALJ.
And the last issue pertaining to the rate structure, tariff structure, purchases of receivable, and the administrative component of the purchases of receivable. We note here the motion of Commissioner Cawley.
I'd like to recognize Commissioner Cawley for purposes of his motion.
Thank you, Chairman. I ask that it be placed on the record as if I had read it in its entirety. One of the competitive issues in this rate case is the determination of the administrative cost component of the purchase of receivables. Direct Energy Services recommended that PPL refund all amounts under the administrative component of the POR through a 0.05% credit to the POR discount rate until the amount PPL has collected is returned, since PPL failed to track the incremental costs. Direct Energy testified that PPL collected approximately $1 million since the charge's inception. PPL argued that it has incurred incremental POR expenses and that POR program rates set in a Section 1308 rate proceeding cannot be retroactively changed. Administrative Law Judge Caldwell determined that Direct Energy did not sustain its burden of proving that its alternatives are appropriate choices for the Commission in a rate case. I believe that it is disappointing that PPL did not track these costs because the administrative component of the POR rate was designed with cost recovery of incremental costs in mind. However, the tariff did not provide for these refunds. In order to avoid a repetition of this in the future, the parties should address the issue in future proceedings so as to provide a more equitable outcome. Going forward, PPL should be directed to track and make an appropriate filing with the Commission, describing all revenues and incremental costs to develop, implement, and administer the POR service, including costs since inception associated with implementation of its POR service, if it desires to seek any further administrative cost recovery in the future. If at that time it is determined that PPL over-recovered historical administrative costs, future cost recovery will only be allowed once the historical over-recovery is netted out. Therefore, I move that the recommended decision be approved as modified by this motion and that the Office of Special Assistance prepare a consistent order.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
Mr. Chairman, that concludes the conduct of the binding poll. Our staff will prepare an order consistent with the poll for entry prior to the statutory deadline. Continuing now with the presentation of public meeting agenda items and additional matters of cases of special interest. At the bottom of page 1, it is recommended that the Commission adopt the recommendation with regard to PECO Energy Company's Phase 2 energy reduction targets.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
On page 2, it is recommended that the Commission adopt the recommendation pertaining to the First Energy Company's Phase 2 energy reduction targets.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
Turning now to matters presented on behalf of the Bureau of Technical Utility Services in omnibus fashion, it is recommended that the Commission adopt all items appearing on pages 3, 4, 5, and 6 through and including the matter pertaining to the investigation of the CSX crossing in Somerset County.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
On page 7 of the public meeting agenda, we recommend the adoption of the 2 items appearing by the Bureau of Audits, concluding with the recommendation pertaining to Pine Row Natural Gas Company.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
On page 8 of the agenda, on behalf of the Bureau of Consumer Services, we recommend the adoption of the Universal Service and Energy Conservation Plan recommendation pertaining to the People's Natural Gas Company.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
On behalf of the Office of Special Assistance, commencing on page 9, we recommend the adoption of the first item pertaining to the formal complaint proceeding involving Michelle Peffer versus PECO.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
We recommend the adoption of the staff recommendation pertaining to the complaint proceeding involving Core Communications versus AT&T Pennsylvania LLC and TCG Pittsburgh.
So moved.
Second.
Any discussion?
Chairman, I wish to be recorded as concurring in the result only.
So noted. Any further discussion? Any objections? Hearing none, the motion passes excuse me, unanimously, noting that Commissioner Cawley will be concurring in result only.
On page 10 of the public meeting agenda, we recommend the adoption of the first item pertaining to the complaint proceeding involving John R. Starsman versus Pico Energy Company.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
We recommend the adoption of the staff recommendation pertaining to the application of Peregrine Keystone Gas Pipeline and the petition for reconsideration filed therein.
So moved.
Second.
Any discussion?
Chairman, I wish to be voted in the negative. I would have granted the petition for reconsideration.
So noted. Any further objections, or excuse me, any further discussion? And noting the objection of Commissioner Cawley, motion passes 4-1.
In omnibus fashion, Mr. Chairman, we recommend the adoption of all items appearing on pages 11, 12, 13, 14, 15, and 16 through and including the interconnection agreement of Frontier Communications and Sprint Spectrum.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
On behalf of the Bureau of Technical Utility Services, in omnibus fashion, we recommend the adoption of all recommendations appearing on pages 17 and 18 through and including the C.E. Dunmire Gas Company application proceeding.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
On page 19 at the top, we recommend the adoption of the staff recommendation in the UGI application proceeding involving the natural gas pipeline located in Tioga County.
So moved.
Second.
Any discussion?
Yes.
Commissioner Gardner.
I'd like to be recorded as concurring in result only.
So noted. Any further discussion? Any objections? Hearing none, the motion passes unanimously, noting that Commissioner Gardner will be concurring in result only.
In omnibus fashion, we recommend the adoption of the remaining two items on page 19, as well as all items appearing on pages 20, 21, 22, 23, and 24 through and including the Verizon North LLC 2013 annual price change opportunity filing.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
On behalf of the Law Bureau, in omnibus fashion, we recommend the adoption of all items appearing on pages 25, 26, and the first two items through and including the petition, the recommendation pertaining to the petition of Valley Energy, Inc.
So moved.
Second.
Any discussion?
Mr. Chairman, I'd just like to take a opportunity this morning, particularly on the Gable Company Ltd. Matter, and take a moment to recognize one of our team members on this case. This was a fairly complex case, and I wanted to recognize Carl Hissera this morning for an excellent job in this matter.
So noted. Any further discussion? Any objections? Hearing none, the motion passes unanimously.
Turning now to the recommendation pertaining to the joint petition for a declaratory order and the proceeding involving the Office of Consumer Advocate and David K. Ebersol Jr. It should be noted that there is your chairman, your motion, Mr. Chairman, which is a joint motion with Vice Chairman Coleman. There are also two statements, individual statements of Commissioners Cawley and Gardner.
I'd like to recognize Vice Chairman Coleman for purposes of reading the joint motion here this morning.
Thank you.
Vice Chairman, sorry.
Thank you, Mr. Chairman. We asked our joint motion be entered into the record as though we have read it in its entirety. Before the Commission is a joint petition seeking a declaratory order that Verizon Pennsylvania cannot lawfully meet its broadband deployment obligation to the Greensburg Community Service Area 1125 through 4G LTE broadband service offered by Verizon Wireless. This request for declaratory relief presents the Commission with two threshold legal issues. First, whether the Commission has the authority to require Verizon PA to use a specific broadband technology at a designated price to meet its bona fide retail request commitment. And second, whether the Commission can require Verizon Pennsylvania to provide retail broadband access service without using a joint venture. We conclude that the answer to both of these questions is no. To summarize the legal analysis appearing in the written joint motion, we note the following. Chapter 30 is clear that the Commission cannot require Verizon Pennsylvania or any other LEC to use specific technologies to meet broadband commitments. Verizon Pennsylvania's network modernization plan, which the Commission approved, contains express language that the company can use any technology available to meet its BFRR commitment. Although we sympathize with the price concerns raised by joint petitioners, neither Chapter 30 nor Verizon Pennsylvania's Commission-approved NMP imposes any explicit pricing requirements or conditions on what carriers must charge for broadband service, including broadband service offered through a BFRR. Chapter 30 is clear that LECs may use joint ventures to deploy broadband services. Chapter 30 seeks to establish local exchange carriers universally available broadband service customers within a LEC service territory. The General Assembly has given LECs flexibility in determining how to best meet their Chapter 30 broadband deployment obligations and serve their customers. This flexibility allows LECs to evaluate BFRRs on a case-by-case basis and use the technology that makes the most sense for a particular BFRR. This flexibility opens the door for LECs to bring new and evolving technologies like 4G LTE to communities requesting advanced services for the investment in infrastructure and advancing technologies in rural Pennsylvania. We view such investments as critical to ensuring that all of Pennsylvania's rural customers are not left behind and have access to faster and better broadband service. We find, however, that our inquiry is not concluded by simply answering the broad legal issues presented in this petition. Rather, our inquiry also includes whether Verizon Pennsylvania exercised its legal authority properly in handling this BFRR in a lawful and reasonable manner. The Commission retains authority to monitor and enforce the compliance of participating LECs with their obligations under Section 3014. In doing so, the Commission retains the authority to ensure that the LEC's communications to their customers comply with Code Section 3014, subsection C3, Part 4 and 5. We are troubled by how Verizon handled the BFRR from a customer service and communication perspective. Verizon PA's actions appear to have caused the Greensburg CSA 1125 customers to believe for an extended period of time that they would be receiving DSL service to meet their BFR request filed in July 2010. However, the customers were informed late in the process that 4G LTE would be used instead of meeting the BFR request for broadband service via DSL. In addition, the customers also complained that they did not receive adequate communications about price, speed options, and service reliability. We are also concerned about LECs using the aforementioned deployment flexibility under Chapter 30 to game the BFRR process. To address this issue, we have directed Verizon Pennsylvania to provide certain information related to the deployment schedule for the Greensburg CSA 1125 BFRR. The specific information requests appear on pages 4 and 5 of the written joint motion. Although an LEC may use a joint venture to deploy advanced services, we stress, as stated in Chapter 30, that an LEC is mandated certain broadband deployment obligations in its service territory. In other words, the LEC cannot use a joint venture to delegate to another entity the LEC's responsibility to meet its broadband deployment obligations. To ensure that LECs carry out the broadband deployment obligations in a lawful and appropriate manner, the Commission seeks additional information on Verizon PA's joint venture with Verizon Wireless to provide advanced services to BFRR customers. The specific information request can be found at page 5 of the written joint motion. Responses to the information request are due within 15 days after entry of what will be a tentative order. Comments addressing the responses to the information request are due 10 days after the submission of the responses to the information request. Therefore, we move that the petition for a declaratory order is denied consistent with this joint motion. The docket in this proceeding is to remain open for the submission of information requests and comments consistent with this tentative order, and that the Commission's Law Bureau draft an appropriate tentative order consistent with this joint motion.
Second.
Any further discussion? I believe we have a statement from Commissioner Cawley.
Thank you, Chairman. I will spare everyone reading my 9-page dissenting statement. But I would say this much.
Please. If it pleases.
I intend to make extemporary remarks that will be longer than the 9 pages. I think it's deplorable that the company strung these customers along for 2 years and then conveniently sloughed them off to an affiliate at a higher cost. I think it's laudable that the majority has issued this in a tentative order fashion and has sought further information with directed questions. However, I think it's premature to reach the legal conclusions that are in the tentative order. I would have waited till we get further information and then make the legal conclusions. But I asked the interested parties to answer further directed questions that are contained in my dissenting statement.
So noted. Now I'd like to recognize Commissioner Gardner for purposes of his statement. Commissioner Gardner.
Thank you, Mr. Chairman. In the interest of time, I'll also defer reading my statement and ask that it be entered into the record as if I read it in its entirety. I would echo my colleague, Commissioner Cawley. I am very troubled by Verizon's 2-year delay in provisioning any requested advanced services to this community, and I look forward to the information requests.
Thank you, Commissioner Gardner. Before we vote on the motion here, I would like to thank Matt Tatino from the Vice Chairman's office for his efforts on this matter. Matt, job well done. With that, is there any further discussion? We're going to note the objection of Commissioner Cawley, and the motion passes 4-1.
And Mr. Chairman, the record should be clarified to note that Commissioner Cawley's statement has been entered into the record as though read in its entirety.
Thank you.
Continuing with the presentation of agenda items, on page 28, it is recommended that the Commission adopt the recommendation pertaining to Windstream Communications, Inc. and the petition of the 6 Windstream SELECts for a waiver of the Commission's regulations.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
We recommend the adoption of the next matter pertaining to Windstream Pennsylvania LLC, more specifically pertaining to the petitions for a bona fide retail request deployment extension. That's a BFRR request extension, noting the statement of Commissioner Gardner.
So moved.
Second.
I'd like to recognize Commissioner Gardner for purposes of a statement. Commissioner Gardner.
Thank you, Mr. Chairman. I'd like for my statement to be entered into the record as if I read it in its entirety. There are 3 bona fide retail request items addressed at this public meeting. But this one stands out, this one from Windstream, Pennsylvania, LLC, because I see this public utility behaving in a manner that is befitting of a regulated entity. Public utilities should provide all affected parties with comprehensive and clear information up front. Windstream has done this by carefully explaining the options that the company considered to fulfill its shell-fill BFRR deployment commitment in a timely manner. Public utilities should also consider the public they serve by occasionally going one step beyond what is expected. Windstream has done this by offering customers 1 month free broadband service for every month that broadband deployment is delayed beyond the original due date of November 22nd, 2012. As the BFRR process continues, please remember that this action will not go unnoticed. Thank you.
Thank you, Commissioner Gardner. Any further discussion? Any objections? Hearing none, the motion passes unanimously, noting the statement of Commissioner Gardner.
And it is recommended that the Commission adopt the last recommendation of the Law Bureau pertaining to United Telephone DBA CenturyLink's petition for BFRR deployment extension.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
On behalf of the Office of Administrative Law Judge in omnibus fashion, it is recommended that the Commission adopt all of the items appearing on pages 29 and 30 through and including Judge Malillo's initial decision involving Hanover Municipal Waterworks.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
That concludes the presentation of regular agenda items. Turning now to the carry-in agenda, it is recommended that the Commission adopt on behalf of the Office of Special Assistance the two recommendations pertaining to granting petitions for reconsideration, subject to further review on the merits.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
On page 2 of the carry-in agenda, it is recommended that the Commission adopt the Law Bureau's recommendation involving the PA Universal Service Fund and the Solex Inc. contract.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
Mr. Chairman and Commissioners, that does conclude the presentation of agenda items.
Thank you, Cheryl. Great job. And let me conclude by taking this opportunity. I think we're all remiss. We recognize we had a rate case in front of us to hear this morning, and I think we're all remiss in not thanking Judge Susan Caldwell for her efforts. No rate case. It's like doing two-a-days for those of you that played football. It is not an easy task, and I want to thank her for all her participation throughout the process, the public input hearings. And Judge Caldwell, thank you for a job well done here this morning.
Mr. Chairman,
Yes, Commissioner Gardner.
I'd like to be associated with your comments.
Any other takers? Thank you.
I think we all think that. She did a great job on this rate case.
Thank you. With that in mind,